Welcome to another session. On this session, we are looking at judicial review. On that, we have a special package for our litigation lawyers. Motions. So, do you amend motions or not? This question has sprung up arguments in the past, which I witnessed among lawyers. While some are saying that you can amend motions, the other ones are saying that you cannot amend motions. So we got requests to look at this subject, and coupled with the fact that there is a recent judicial decision on it, we decided to feature it today. So the case we are featuring today is the case of Okunola and Soyinka. So we are going to look at the decision on whether motions can be amended or not. The court held that motion can be amended like any other process of court. It can be amended by insertions and alterations therein, or by substituting it with a fresh motion. I think that is clear enough and is unambiguous. Basically, motions can be amended. There is this other argument that always comes with it too, that motions can only be amended by substitution. Well, that decision of the court now has overruled that particular argument too. Okay, motions can be amended. You can amend motions by subtraction, insertion, any other form of alteration, as by simply substitution. So let's get these aspects clear. However, the court went further to give some exceptions wherein an application for amendment will not be granted. You know this funny thing about our law, exceptions actually form the integral part of our law. So we go back to the decision of the court and we read further. The court went further to state that even though the bedlam it in favor of granting amendment, an amendment can be refused in deserving cases. The materiality of the amendment must be carefully considered in the peculiar facts of each case. An amendment will not be granted where it will not avert or cure the defects in the proceedings. Where an amendment is not material but is an inconsistent or useless amendment, it will not be granted. Equally, an amendment will not be granted to create a suit where none existed. Again, this is very straightforward. So you cannot just wake up in the morning and with the mindset to go and waste the time of court, or to buy the time of bring up an application that is targeted at curing nothing, simply to waste the time of court. If you are not lucky, the court may not be very lenient with you. The court may mess you up on that day. So let's get this clear. It is not in one instant you want to court to say you want to make this application. Also, you cannot take advantage of this application to bring in facts that are not before the court. So with this, we come to the end of today's session. You think you have any aspect of the law you want us to look at? Bring it up and we'll look at it. Feature it here. So any aspect at all. If you have any legal article that you want us to review with you, you can send it. Your topic might just be similar to what we are doing next. Who knows? So we'll do it and feature you at the end of the day. Also, do well to follow us on our social media platform to get the full update of what we are doing here. Okay? Before we go, sure, there is one aspect we are going to feature in one of our sections. So maybe you can add your contribution to it. Polygamy have been legalized in Kenya. So people in Nigeria brought up this argument that Nigeria should legalize polygamy. So we'll be looking at that aspect of it. So if you want to contribute, you can send your contribution to that effect before we feature that subject. Okay? So big thanks to everyone that's contributed to the content of today's section, talking about my Pedro leader and of course Stillwater Law Firm. Also to our content source, Legalpedia Law Report. See you in the next session.